What Prop 209 did was to add a paragraph to our state constitution prohibiting the use of affirmative action techniques, race-conscious, gender-conscious affirmative action techniques in public education, public employment, and public contracting. Perhaps most notoriously, the immediate impact of Proposition 209 was a dramatic drop in the number of African-American and Latino students at our University of California campuses. Perhaps most notoriously, the University of California at Berkeley Law School ended up with only one African-American student in the first class selected after Proposition 209, and that individual had actually been admitted previously and deferred his enrollment. But today, 24 years later, we continue to see the impacts of Proposition 209. I'll give you just one statistic. Today in California, African American and Latino students make up 60% of 12th graders in our public schools statewide. 60% of those who are high school seniors and on the cusp of going on to higher education. And yet, at our University of California system-wide, African Americans and Latinos make up only 29% of undergraduates. 60% of 12th graders, only 29% of UC undergraduates at all campuses. That's a measure of the dramatic disparities that we continue to see in the state of California and that we are not able to address aggressively because of Proposition 209. But I do want to highlight what else has changed in 24 years. First, the demographics of our voters have changed. So those supermajorities in opposition to Proposition 209 among African Americans, Latinos, and Asian Americans, if those percentages applied today, the outcome would have been different. Because today, voters of color comprise 42 to 43% of all registered voters in the state of California. That's substantially higher than it was in 1996. So such a racially divisive measure would not have the same outcome as we saw 24 years ago. But something else has changed in 24 years, and that is our United States Supreme Court has weighed in on a number of occasions about race-conscious, gender-conscious affirmative action programs in public education, public employment, and public contracting. Specifically, in the ensuing 24 years since 1996, the U.S. Supreme Court has addressed affirmative action in higher education twice in the University of Michigan cases, Gratz and Grutter, and after that, twice more in the same case of Fisher versus University of Texas. In the area of employment, in the Ricci case versus City of New Haven, in 2009, the U.S. Supreme Court has addressed affirmative action in employment. The upshot of all of this is that the U.S. Supreme Court has become much more descriptive about what is permitted and what is required in pursuing affirmative action. First of all, even before Prop 209, we know that the U.S. Supreme Court has prohibited anyone from using quotas or set-asides based on race or gender in any of these public realms. Since 1978, a case called Bakke versus University of California, out of Davis Medical School, the U.S. Supreme Court has made clear that we cannot anywhere in this country employ quotas or set-asides based on race or gender. But more recently, in the cases I've described, the U.S. Supreme Court has made it clear that any public policy-making entity interested in using affirmative action must first go through a rigorous analysis and consideration of policy changes before it may put in place a narrowly tailored program to consider race or gender. The U.S. Supreme Court has considerably narrowed the circumstances under which anyone can employ race or gender conscious affirmative action. And those restrictions would apply in the state of California even after Proposition 16 is enacted. What is required is a rigorous examination of disparities like the percentages that I described between 12th graders and UC undergrads. Anybody interested in implementing affirmative action must look carefully at those disparities, identify the causes of those disparities, and consider whether there are race-neutral and gender-neutral approaches to addressing those disparities before an entity can consider a race or gender-conscious affirmative action program. What that means is that some of the most important progress from Prop 16 may well be in the form of changes that are race neutral or gender neutral that result from that rigorous analysis and policy consideration mandatory in California by the US Supreme Court. So for example, we might see race neutral, gender neutral changes in admissions criteria with positive effects for all races and genders created as a result of Proposition 16. The problem you see is that Proposition 209 has prevented the University of California and other public entities from engaging in the rigorous analysis and policy consideration required by the US Supreme Court, because in the end of implementing affirmative action, and as we all know, no politician wants to highlight an issue like racial or gender disparities if they then are prevented from putting a solution in place. So because Proposition 209 has prevented us from considering any affirmative action programs, our policymakers have simply not engaged in that rigorous analysis of racial and gender disparities, engage in that careful consideration of policy approaches, including race and gender neutral approaches to addressing those disparities. We have basically been prevented in this state from engaging in that kind of careful consideration of what we all now see as a result of the pandemic, the recession, and the Black Lives Matter movement. It's for this reason that we believe that opportunity for all Californians will be promoted by the passage of Proposition 16. It will enable all of our policymakers to engage. Indeed, it will put great pressure on our policymakers to engage in that rigorous analysis and careful consideration that the US Supreme Court has described. Proposition 209 also affected what kindergarten through 12th grade school systems can do. And I will give you an example of where it was nearly an impediment to an important policy reform that was implemented. The local control funding formula that provides additional resources to schools based on the number of foster youth, youth from low socioeconomic circumstances, and English learners was actually delayed because there were legislators who were concerned that LCFF, the local control funding formula, would violate Proposition 209. And that is because English learner category, for example, overlaps very heavily with Latino and Asian American students with racial categories. So foster youth overlaps very heavily with African American students. So the legislature was concerned that it would be viewed, although it is a race-neutral solution because it focuses not on race, but on low SES, foster youth status, and English learner status. It is race-neutral and therefore permissible, but they paused and even sought outside legal advice to assure them that they could engage in that kind of step in K-12 public education. Second, I understand that folks who have relied on a particular set of criteria for admission for a long time have concerns. That's why I emphasized how carefully the approach to affirmative action must be under US Supreme Court precedent. And the state of California cannot get out of those requirements. This is a very careful and rigorous assessment before changing criteria. But there are clearly criteria that have a discriminatory effect, and that effect is within all races and genders. because we do have a leader in the White House who has built his entire administration around sowing greater division, around encouraging people to see themselves as part of subgroups, and then he clearly indicates who he thinks of those subgroups should be on top first, and those implicitly who are left behind. But I think what we see, particularly in the last 6 months, in the reaction to the police murder of George Floyd, as we had seen on video many police murders previously. But I think we've seen a far more vigorous response following George Floyd's murder and the subsequent events. And I think that demonstrates a hunger to react to what is being created by Donald Trump, and a hunger to have greater unity around eliminating discrimination. And the other thing that I will say is discrimination has costs for all of us. The only way, economic costs, that's been documented. If you don't address inequities, your ability to grow the pie for everyone is severely limited. So the way to get out of zero sum is actually to embrace equal opportunity for all, because that's the only way we're going to expand the pie for everyone and eliminate the notion that this is zero sum.